Okay, so in your chat box, right, we're going to answer the questions as they come up on the screen. Answer them the way you see fit, okay? It's good practice. All right, you ready? The North Carolina Real Estate Commission may, after hearing a hearing, take disciplinary action against a North Carolina licensee who has, 1, violated any of the provisions of the North Carolina Real Estate License Law, and 2, been disciplined by the South Carolina Real Estate Commission. So is it 1, 2, both? Yeah, it's both. All right. Yeah, it is both. And the reason it's both is because not only do you have to, well, obviously they're going to report the North Carolina violations, but you have 60 days to, if you've been disciplined by any other licensing authority anywhere. So whether it's South Carolina Real Estate Commission, whether it's a cosmetology license, whether it's a appraiser's license, whether it's any kind of license whatsoever in any state, you have 60 days to go and tell the Real Estate Commission, all right, to let them know, the North Carolina Real Estate Commission, okay? All right. Okay, a real estate license must be renewed no later than every when? Anniversary licensure, June 10th, December 31st, June 30th, which is it? Yeah, the renewal date is June 30th. What's the 10th? The 10th is what? The last day we can take CE, right? CE. Yeah, the last day we can take CE. So those are 2 dates that we need to remember. All right, the 10th is the last day we can take CE. The 30th is when we have to renew by. Continuing education. In North Carolina, all real estate brokers must A, maintain a trust account, B, belong to the local board of realtors, C, complete continuing education each year in order to keep the license current, or D, include their firm's name in advertisements of a client's properties. Okay, this is a real good question because this is something we covered earlier. All real estate brokers, here's an absolute, okay? Do all real estate brokers have to maintain a trust account? Only if you're taking other people's money, right? If you're not taking their money, you don't need a trust account, right? Same thing with brokers in charge, firms. If you're not taking other people's money, you don't need a trust account. The board of realtors, we do not have to belong. Only about 70%, 65 to 70% belong to the board of realtors. It is a professional organization. It's bound by a board of ethics, code of ethics. Usually if your broker is a realtor, he will ask you to join, and then at that particular point, you'll join. But otherwise, we have companies that are not realtors. And letter C, we talked about earlier, complete continuing education each year in order to keep their license current. We talked about the provisional broker, right? They don't have to do it in the first year. So that means that that one's not true either, okay? The only must here, and here's the key word is must, right? Include their firm's name in advertisements of a client's property. If the firm's name is not in there, it's considered a blind ad. So you may see something that asks you about a blind ad. What's a blind ad? And a blind ad means that the firm's name is not in the advertisement. How many days does a provisional broker have to deposit earnest money? Here's a no later than 3 banking days from receipt, no later than 3 banking days from contract acceptance, no later than 5 business days excluding national holidays, none. A provisional broker has none days. A provisional broker must give the earnest money to their broker in charge immediately, okay? So they don't have a 3-day exclusion. Normally, your broker in charge would have 3 days if it's cash, 3 days from receipt. If it's a check, 3 days from the acceptance of the offer, all right? When we have an offer, when we have a contract, all right? The ratification of the contract, 3 days. But until then, if you're a provisional broker, you don't have any, you got to give it directly to your broker in charge, okay? So provisional brokers do not deposit trust funds. True or false? Any financial institution holding trust funds for a real estate broker must make their records available to the North Carolina Real Estate Commission for inspection purposes. Yeah, absolutely. So any bank that's there have to be, if the if an attorney is holding the money, they have to let them inspect. Okay, all of it. Joanne Broker of Go Realty is showing houses to her client. They look at 10 houses before he asks to see the one that is listed with Go Realty. On his buyer's agency agreement, he declined dual agency. Can Joanne Broker show him a house listed with Go? Okay, at this point, you are right, no. However, when all is not lost. So after we can get written authority, we can go back and revisit. So even if they said no on their initial agency agreement or their initial buyer's agency agreement, listing or buying, we can go back when we have an opportunity. But before we can show it, we need to have it in writing, give them a chance to change their mind. They don't know what their perfect house is, right? I mean, they have an idea, but they don't know who it belongs to. So why would they give up their perfect house if it, just because of a technicality like that? So you got to give another opportunity. So no, you can't, not until you go back and say, okay, you got to get, I need written approval to do dual agency or designated agency. Once they do that and the seller does the same thing, then you can go ahead and show the property. True or false? The offer to purchase and contract addresses the seller's remedy for breach of contract by the seller. All right, we haven't covered this yet, but yes, it does. All right, the earnest money that you put up as a buyer becomes, and when we do chapter 10, we'll see this, it becomes liquidated damages. So in the contract, it says that if the buyer puts up money and the buyer walks away for no good reason, the seller is entitled to the earnest money as liquidated damages. It says so in the contract, and we'll see that. All right, but we haven't covered it yet, so I'm giving you the answer here. So the answer is true. It explains the forfeiture of earnest money if buyer breaches contract and other options beyond earnest money. So there are some other things that could happen here. Okay. All right, so we'll see that down the road. True or false? Joanne Broker is a provisional broker with Go Realty. Therefore, she cannot work as designated dual agent with David Bennett, also a provisional broker of Go Realty. Yeah, she can work with another provisional broker. She can just not work as a designated agent with her own broker in charge. Okay, can't work as a designated agent. So she can absolutely work as a designated agent with another provisional broker. However, she cannot work as a designated agent with her broker in charge, right? Well, or anyone from another firm. There's no, if somebody's in another firm, there's no designated agency. So I don't know why that's there. True or false? As the seller's agent, you are required to verify the accuracy of title charges on the settlement statement. Who pays the title charges on the settlement statement? Who would pay for a title search? Y'all, most of you bought houses. Who would pay for a title search? The buyer, right? What's the question say? As the seller's agent, you are required to verify the accuracy of the title charges. Again, please read the questions. All right. False. That would fall under the buyer's broker's responsibility. Seller's agent would verify items such as excise tax, due diligence amounts, other terms that affect the seller financially. Seller's agent is going to take care of the seller. The listing agent is going to take care of the listing. The buyer's agent is going to take care of the buyer's side. In this particular case, title charges are on the buyer's side. When two parties to a contract agree that a breaching party will pay the other party an agreed upon monetary amount, this is an example of, all right, we just talked about this, and this is liquidated damages, right? Earnest money, one way or the other. Now, we'll also talk about what's called specific performance when we get there. The buyer can sue for that if they want the house bad enough. We'll talk about that when we get to contracts. Chapters 9 and 10 that's coming up. Okay, so any of that monetary amount that goes to the seller, to the buyer, yeah, the court makes them sell it. Exactly right. It's liquidated. Okay, when calculating a property management operating budget, what is never included? Now, we haven't talked about property management yet, so I'm going to give this to you. All right. You don't use, when you do a budget and you figure out your estimated income for the month, and you figure out all of your expenses or estimated income for the year and all of your expenses for the year, that's going to give you a net operating income. But we don't take that out. We don't take mortgage and debt service, what they're going to pay for mortgage and interest. We don't take that out until after we find the net operating income. And that's just an accounting principle. I know that we're not accountants, but when you're doing net operating income and you got to figure out value based on that, all right, mortgage comes out afterwards. And after you deduct the mortgage out of the net operating income, that becomes cash flow. Okay. When we get to chapter 15, no, we'll do it in chapter 12. We'll talk about, we'll do it in a couple of different places. So just hang in there with that. But just know that mortgage comes after net operating income when we're doing the costs. How long is an oral listing agreement valid before it has to be put into writing? Is there such a thing as an oral listing agreement? Listing agreements have to be in writing from the beginning. There's no such thing as an oral listing agreement. True or false? An oral buyer's agency agreement must be put into writing within 7 days to remain valid. An oral buyer's agency has no time limit, but must be put in writing by the time of presenting the first offer or restricting the client from working with other brokers. So we have no time limit on an oral buyer's agency. We can't stop them from working for other brokers. We can get a commitment that says that we can work, we can give them our old car responsibilities, right? Our fiduciary responsibilities, but we can't stop them from working with somebody else. So we want to, before we present an offer, we need to get it in writing. There's no protection for the broker in oral buyer's agency. Technically, the only protection that you have has to do with your ability to give advice and counsel and judgment and things of that nature. That's your protection, okay? So that you don't get implied agency against you. Implied agency is a dangerous thing. If they don't want you to be an agent, you can't start giving them advice and counsel, all right? But this saves you from that as long as they agree to those, we talk about those 3 things up front and they agree. But before you present an offer, you have to have it in writing. True or false? An unlicensed person has been helping friends locate and negotiate properties for sale in Atlantic Beach, North Carolina. The North Carolina Real Estate Commission has the authority to investigate his activities and take further action if necessary. Yeah, absolutely. Now, they're going to get the courts to file an injunction, a cease and desist, right? Until this thing goes to court, and then the courts will handle it from there. But they can investigate it, send it to the court. True or false? All North Carolina agency agreements, listing, buyer's broker, etc., must include the broker's license number and an anti-discrimination clause. Absolutely. Absolutely. Okay, true. The anti-discrimination clause and your license number will be in everything. True or false? Brokers are required to retain the working with real estate agents disclosure for 2 years. 3 years, right? We keep everything from when the time we stop working with those folks for 3 years. Which scenario best demonstrates first substantial contact? Number 1, buyer says they like the local school district. Number 2, seller states they hope to sell within 6 months. Seller 3 states they must relocate in 2 months. Number 4, buyer shares their desire for 3 full baths. Which one is first substantial contact? Yeah, the must, right? Price, terms, motivation. He's got motivation. Right? He must. He's got to relocate in 2 months. Okay. So that is number 3 is correct. All right. They must. True or false? A dual agent may disclose confidential information about their seller client to other brokers working for the firm. Actually, it is true. Because we work for the broker in charge, who's really the dual agent? The broker in charge, right? And we are all seller subagents. So we can give information amongst our building. I would be very careful about that because nobody's going to get hurt if other agents that go in our particular building is going to find this information. However, let's say I'm in the lunchroom one day. I had a house that I listed for $250,000, just went under contract for $245,000. And I go into the lunchroom and I go and blab to everybody. I got a contract for $245,000 on my $250,000 listing. That was fantastic. Very excited. 3 days on the market. It's off. Excellent. Let's go to close. And I can do that. Here's the problem. What happens if that deal falls apart? Then everybody in that lunchroom now knows the price that my seller will accept, right? So therefore, if they're put into a designated agency agreement where they bring the buyer, we may not be able to handle that because they know what the information is, right? So also, they're not going to offer any more than $245,000. Okay. A broker, property manager in North Carolina can deposit rent checks directly into the bank account of the property owner. No, they got to go into the trust account, right? That property owner is going to have to owe us some money. We're going to have to get our commission. We're going to have to get any expenses that we put out. We're going to have to get any of that stuff. So we're going to give them a monthly statement or a quarterly statement that says, okay, this is your income and these are your expenses and here's a check for the rest. So we're going to have to lay that all out for them. So we can't just give it directly into their bank account because we won't see our money anymore. True or false? At closing, a North Carolina buyer's agent in a residential transaction is expected to verify that the settlement entries reflect the terms of the sales contract and all the amendments between the parties. True or false? Yeah, this is true, okay? This is true. Now, we're not going to be, like I said earlier, I don't know what title costs are. That changes every day. It's like insurance policies, right? I can tell you if it's too high or too low. And then at that particular point, I could say, hey, make that change. I think there's something wrong here. And then verify this or verify that. And you'll be calling. But you're going to be studying, you're going to be looking at that closing statement, make sure that everything's there. Is the commission right? That's one of the big things. Because even though we say that commissions are negotiated, and they are, commissions are negotiated, a lot of times paralegals always assume it's the same commission split for everybody. And maybe this one isn't. But when you get the closing statement, guess what they're going to do is that paralegal is breaking out that closing statement. They're going to go to what they think is the default, and it would be wrong. So therefore, you got to check and make sure the right commission got charged. It could be anything, right? All of those things. The right sales price, maybe it went back and forth. Maybe your seller is going to give your buyer an allowance for $2,000 or $3,000 or whatever. Make sure it's in there, right? All of those things got to be in there. And that's where you got to go in there and check and make sure it happens. True or false, a dual agent representing a seller is not permitted to share material facts about the condition of the property with the buyer. Yeah, we got to share it with everybody, all right? Material facts are shared with everybody, whether we're the seller's agent or we're the buyer's agent, it doesn't matter. These are material facts, okay? We must share them. A broker advertises his individual condo as having a great view of downtown Raleigh. And you can actually only see downtown Raleigh from the rooftop of his building. The agent is guilty of what? What's the agent guilty of? Is this measurable? If this is measurable, it's not puffing. He said you can see it from the condo. I went there to look at it, and we had to go up to the rooftop to see it, not from his condo. Therefore, that is willful misrepresentation. Okay, willful misrepresentation. That's not true. All right, that's not true. Maybe from the rooftop, if he said, hey, if you buy this, you can go to the rooftop and have a great view of, bring your lounge chair and go sit up on the roof and see downtown Raleigh. That's fine. But he didn't say that. Willful misrepresentation because he said it. Okay, because he said it. If a buyer, seller, client wishes to add unique provisions to the contract that would not be covered by the standard addendums, broker should advise the client to do what? You want to add, they want to add something to the contract and we don't have an addendum to cover it. What are we going to do? There we go. You got it, right? We're going to hire a lawyer, right? We're going to get the attorney to draft the addendum. And let me give you an example. I've seen so many contracts where agents write in the additional information line, contract is valid upon satisfaction of a inspection. And it's written in there, right? Agreement will be based off of satisfactory inspection. Who's satisfied? When? Who's got to pay for it? All those things need to be in there, right? We can't have any ambiguity. That's why an attorney should draft these. Because we don't do it right. We leave out so many details. How long do we have to do this? Right? All of those bits and pieces have to be added in there. It's not just a one-line answer. So that's why we get the attorney to draft the addendum. All right? Otherwise, you just keep going on. Use too much ambiguity. All right? You got to make sure they do it. And we're not lawyers. We're going to be brokers, right? Real estate brokers. True or false? A broker is required to disclose that a property is within a federally recognized flood hazard zone as a material fact to all prospective buyers. True or false? Yeah, absolutely. That is a material fact. That's true. Very true. All right. True or false? The only pre-printed sales contracts that brokers are allowed to use in North Carolina is the standard form drafted by the North Carolina Association of Realtors. There you go. You guys are paying attention. Good deal. They can use any attorney drafted contract as long as it meets the standards of the Real Estate Commission. All right. And has important details such as legal property description and the manner of payment. There's part of them. There was 19 clauses the last I checked. And it changes all the time, but there are 19 clauses that have to be covered. All right. So it can be drafted by an attorney. As long as it's attorney drafted. True or false? We're closing in on it. We're getting near the end. To be considered heated living area, a room must have a minimum ceiling height of 7 feet. And when measuring slope ceilings, we stop at 5 feet. True. True. That's the definition. Has to have a minimum 7 foot. And it can't be lower than 5 feet. True or false? A licensed appraiser must have an active broker's license to manage real property for another person. Yeah, he needs a real estate license, right? If we're doing something, we're doing real property for others for compensation, right? He's managing it. Their appraiser license does not cover that. Right? He needs a broker's license in addition to his appraiser's license. Right? So it is true, they do need a license. True or false, a licensed real estate broker may draft a loan contingency addendum for their buyer client. Yeah, no way, Jose, you can't do that. Only attorneys can draft addendums, and we already have pre-printed ones. We have a bunch of them. All right, material facts relating directly to the property, such as scheduled road expansion, must be disclosed, 1, to no one, 2, to anyone who asks about the issue, 3, to all prospective buyers. Yeah, all prospective buyers. That's it, right? All right, I'm going to take a few minutes, all right, to go through those notes, the appendix notes, all right? It's really important that you use all of things, all these materials that you possibly can use. Okay, these are those review notes, okay? Very important that you go back and these have actually more detail in some cases than our slides do, as does the key point reviews, okay? We gave you, I mean, we can go through slides and slides and slides, but never cover all of the other points. So that's why these 3 docs are all important together. The key point review at the book on page 278, these notes and this slide deck, all very important. The Real Estate Commission, created by General Statute 93A, and it became effective in 1957. I have not seen a test with that on there yet. So just know that it's a general statute that was put together by the state in 1957. The commission's primary duty, and we talked about this, primary duty is to protect the public in their dealings with real estate agents. Okay? So their job is to protect those other folks, not us so much. Now, our real estate commission consists of 9 members, 3-year staggered terms, okay? 7 of them are appointed by the governor, 1 by the Speaker of the House, and 1 by the President Pro Tem of the Senate. So the governor has 7, 2 by the General Assembly, 1 by the Speaker, 1 by the President Pro Tem of the Senate. Again, 3-year staggered terms. Must have 3 people with a license out of the 9, and must have at least 2 at large, no license, all right, general public. And the rest can be made up any way they want. So the Real Estate Commission has some powers, right? They can license brokers, they approve schools, courses, believe me, they do. Conduct education programs for public and licensees. Discipline licensees who violate license law and commission rules, all right? Regulate timeshares. They can investigate licensees on receipt of complaint from a consumer. They can investigate licensees upon their own motion without cause. They can wake up one morning and just say, Shanta, guess what? We want to see your records for the last 3 years. Let's see them. And Shanta says, what? And you say, yeah, you're supposed to let them do it. Usually what happens when they do it, when they do an investigation, they will call the broker in charge. And they're going to call them and say, we're going to come tomorrow. We're going to, or they could walk in. It's perfectly within their rights. But they're going to go through the broker in charge stuff first. They're going to make sure your trust account is up. They're going to make sure your documents are there for 3 years. They're going to make sure that all of the records and all the record keeping is up to snuff and they're handling the money the right way. If the broker in charge is done well, usually agents don't hear about it. Might be the rare one that they'll pick out. But if your broker in charge does not do a good job, guess what? They're going to, hey, what did I say? The dirt rolls downhill, and use another word for dirt. That's what happens. And then all of a sudden now the agents are being called in, the brokers are being called in to say, let's see this and let's see that. So make sure you're working with a broker in charge who's got his or her stuff together. So the Real Estate Commission can reprimand you, censure you, suspend you, revoke you, right? All of these things they can do. And they're the only ones who can take your license. However, they can't fine you. They cannot fine you. So you're responsible to the Real Estate Commission for all actions concerning real estate, including buying, selling, or leasing your own property. You can be a for sale by owner. You're allowed to do that. However, you must, because you have a license, you have to follow the Real Estate Commission rules. Okay, you have to follow all the rules for the Real Estate Commission. It's not like you're selling it as a, an unlicensed owner. The Real Estate Commission can't fine you unless it's for timeshare thing. Yeah, that would be the timeshare. Yes, that would be the timeshare missing registrations. They have a pretty big issue. Now, there's something in here that we'll see a little later, but any violation, let me go back here. Any violations of General Statute 93A, becomes a legal issue. So if you violate any of the real estate commission rules, it's a legal issue. So what can they do? Put you in front of a judge. Judge doesn't have the same rules, right? The judge can fine you. And then the real estate commission can take your license after that, okay? But for us as brokers, unless we're involved in timeshares, we can't be fined, right, by the real estate commission. All right, so regulate timeshares, investigates complaints. Let's see, what else we got here? $45 every year. Now, the real estate commission, this is not testable, I don't think, but it's self-funded. So there's no budget for the North Carolina Real Estate Commission. So that's why they're funded through the $45 a year that you pay for your agent as for your license. They're also funded by that application fee, that $100 application fee that you're going to pay. Okay. So they believe me, when you pay to sign up for this class, we have to pay the real estate commission, right? So they get money from everybody for being part of this. So that's how they make their money. So they're self-funded. They are not funded by any kind of budgetary line in the state government. That's why synchronized classes are good for them. All right, so all licenses expire on June 30th, unless you renew it. So the Real Estate Commission cannot practice law, all right, to determine if contracts are void. Attorney's got to do that. Real Estate Commission got to do that. They can't regulate commissions or salaries. So if you have a dispute with commission, if you have a dispute with your salary or anything else like that, Real Estate Commission is not going to help you. And they're not going to arbitrate between parties who are arguing back and forth or money's returned. They're not going to do that. That's going to be within your broker in charge. If you're a realtor, you're going to go to their organization. If not, you're going to take it to the courts yourself, the magistrates usually. So the definition of that real estate broker, any person, partnership, corporation, limited liability company, association, or any other business entity that conducts any of the activities required for a real estate license. Real property for others for compensation. That's what you got to remember, right? Put that concept in your head. And it's all for all of these, if you want an acronym, the LLBEANS, right? List, lease, buy, exchange, auction, negotiate, sell, right? For others for compensation. Right? That's really what you need to worry about. Who doesn't need a license? For sale by owner, don't need a license. A mere crier at an auction, the person doing the auctioning. The auctioneer himself does need a license. Person acting under a power of attorney. You're working as somebody else, you're acting as somebody else, so you don't need a license. An attorney in the course of law practice, as long as he's doing the closing, and he's doing the settlement, he doesn't need a license. But if he's out on Tuesdays and Thursdays selling real estate to clients, he needs a license. An appraiser doesn't need a license. Bankers, persons negotiating financing don't need a license. A trustee in a bankruptcy, right? They do not need a license. Corporations selling their own property do not need a license. Again, they're selling their own property. It's as if they were for sale by owner. Resident manager employed by a property manager on a salaried basis. They get paid W-2, get paid the same amount whether something sells or not. They do not need a license. And they cannot negotiate rents or security deposits, all right? And that is that if you're employed by a property manager, you can show properties and things of that nature. You can't negotiate. You're going to come back and fill in the forms, and if you needed to change a price, you'd have to get that property manager's.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.